Jamie Lee Jones spared no details 2 years ago when she told lawmakers she was drugged and gang raped by fellow employees in Iraq in 2005 while working for defense contractor and Halliburton subsidiary KBR.
The next morning, I was extremely sore between my legs and in my chest. I was groggy and confused. I went to the restroom and realized I had bruises between my legs and on my wrist and was bleeding between my legs.
Eventually, Jones fought to sue KBR in open court, despite signing an employment agreement requiring her claim to be handled through private arbitration. An appeals court sided with her, and her story got the attention of freshman Democratic Senator Al Franken.
Asking a victim to enter arbitration with someone who raped her or with a company that wouldn't protect her is outrageous.
This month, Franken successfully pushed through an amendment that would ban the Pentagon from doing business with KBR and other contractors that require employees to agree to arbitration in a number of areas. They include discrimination grievances, sexual assault claims, and sexual harassment claims. Senator Jeff Sessions is one of 30 Republicans who voted against the proposal.
It's a political amendment, really at bottom, representing a sort of a political attack directed at Halliburton.
Republicans cite the Pentagon's opposition to Franken's amendment. The Pentagon says defense officials and its contractors might not be in a position to know about specific cases, and officials argue the amendment would be hard to enforce. A senior official says the Pentagon has reached out to Senator Franken's office to try to rework the amendment. The proposal is attached to a defense spending bill that's now being reviewed by a conference committee. Meantime, KBR has filed a petition asking to re-argue its case before the appeals court. Elaine Quijano, CNN, the Pentagon.
After 62 days of careful and painstaking hand inspection of nearly 3 million ballots, after hours and hours of hard work by election officials and volunteers across this state, I am proud to stand before you as the next senator from Minnesota. This victory is incredibly humbling, not just because it was so narrow, but because of the tremendous responsibility it gives me on behalf of the people of Minnesota. Thank you. Madam President, the amendment I offer today is inspired by the courageous story of a young woman who has dedicated 4 years of her life to make sure that no other woman lives through her nightmare. 4 years ago, at the age of 19, Ms. Jamie Lee Jones signed a contract to become an employee of KBR, then a Halliburton subsidiary. That contract contained a clause which required her to arbitrate any future dispute against her employer. This means it forced her to give up her right to seek redress in court if she was wronged. At the time, Ms. Jones had no idea what implications this seemingly innocuous fine print clause would have. Arbitration has its place in our justice system. For two companies haggling over the price of goods, arbitration is an efficient forum, and the arbitrator will undoubtedly have the appropriate expertise. The privacy that arbitration offers can protect their proprietary business information, but arbitration has its limits. Arbitration is conducted behind closed doors and doesn't bring persistent, recurring, and egregious problems to the attention of the public. Arbitration doesn't ever allow you a jury of your peers. Arbitration doesn't establish important precedent that can be used in later cases. Many of our nation's most cherished civil rights were established by individuals bringing claims in court, the court ruling in their favor, and then extending the protection of those rights to anyone in a similar situation. Arbitration does have a place in our system, but handling claims of sexual assault and egregious violations of civil rights is not its place. Ms. Jones won a small but important victory just a few weeks ago. The conservative Fifth Circuit Court, encompassing Texas, Louisiana, and Mississippi, ruled that most of Ms. Jones' claims do not belong in arbitration. The Fifth Circuit ruled that even when you sign an employment contract requiring arbitration, there are some rights to sue your employer that just can't be signed away. These include assault and battery, infliction of emotional distress, false imprisonment, and negligent hiring, retention, and supervision. The amendment will apply to many contractors that have already demonstrated their incompetence in efficiently carrying out defense contracts and have further demonstrated their unwillingness and their inability to protect women from sexual assault. I urge my colleagues to support this amendment. Thank you, Madam President, and I yield the floor.
But before I do, and before the senator from Minnesota leaves the floor, I want to thank him for bringing the amendment that he just brought to the bill and to ask that my name be added as a co-sponsor. I sincerely appreciate the work and effort.
Without objection, so ordered.
Thank you. And the work that has gone into bringing that amendment, and hope it will see a significant vote here on the Senate floor.